Hello again, my name is David Garaski, and I'm an instructor for both the Hinda Institute and Walder Foundation's course entitled Pursuing One's Legal Rights Post-Petition. The course clip that follows focuses on the best strategies to employ post-release to avoid the dreaded parole revocation. The issues about to be discussed, we hope, will steer you in the right direction and may, just may, turn your probation officer from foe to ally. We hope you enjoy.
One of the things, obviously, everybody who's out on parole faces is the possibility that their parole will be violated. So the United States Supreme Court decided about 40 years ago that at least some people who are facing parole revocation, that is, risking going back to prison, have the right to be represented by a lawyer at their parole revocation hearing. Illinois, like most states, does not have a system where they appoint lawyers. They've just ignored the Supreme Court ruling. So California, some lawyers brought a case challenging that, saying, you're supposed to make individualized determination for each person as to whether or not they need a lawyer to adequately represent themselves because they're facing prison. You can't just throw people in prison without a lawyer, is the general rule in this country, but they were. So ultimately what happened in California was they began negotiating as to exactly what groups of people would be entitled to lawyers and which ones wouldn't. And eventually the state threw up its hands and said, it's going to be easier just to give everybody a lawyer than just to figure out who does and doesn't get one. So now in California, everybody who is facing revocation gets a free lawyer appointed by the state to represent them, assuming they're financially eligible. That's the only criteria. Illinois, by the time California finished that, still had never appointed a single lawyer in the 40 years since the Supreme Court issued their decision. We tried to negotiate with them for a while, and they said, basically, sue us. We haven't got the money. We're not going to do this. If you have volunteer lawyers who want to do it, we'll be happy to let them represent people for free, but it's on you to find them. We said, no, that's not the way the Constitution works. Your constitutional rights are not dependent on a volunteer stepping forward and take your case. You have a right to a lawyer. So we sued. And after several years of litigation, as usual, these things take far too long, we actually filed two suits, one for juveniles and one for adults. The juvenile one settled quite quickly, and they did the exact same thing they did in California, saying it's way too complicated to figure out what juveniles do and don't get lawyers, so all juveniles will get lawyers. As a result, the number of juveniles who were revoked on parole has dramatically dropped from thousands to dozens. And partially a result of that and partially a result of other changes in the system, our juvenile system has shrunk dramatically. We've had to close a whole bunch of juvenile prisons in Illinois so that there are not nearly as many juveniles that are now locked up in a prison. Good all around for everybody. In fact, now they're trying to figure out what to do with some of those empty prisons. A problem I wish every state had was too many empty prisons, trying to figure out what to do with them. So then on the adult side, though, it became much more difficult. And, the scale was different. In fairness to the Department of Corrections, they held like 300 parole revocations a year, or very roughly, in the juvenile system. In the adult system, they're holding more like 10,000. So, 2 or 3 lawyers could handle all the parole revocations for the juvenile system. But on the adult side, you need a whole lot more lawyers. And they happen in all of the 102 counties in the state of Illinois. So they're all over the place, whereas in the juvenile system, they're only happening in 3 or 4 juvenile prisons that they had. So it was a much bigger deal. They never would agree just to throw up their hands and say everybody gets a lawyer. So the handout I gave you sort of lays out the 3 things you have to do in order to get a lawyer in Illinois. And it really reflects the constitutional claim. So the same, well, there's not a settlement, obviously, in every state. The rights are there in every state. It just may not be being enforced. You have to ask. That's the biggest one. If people don't know they're entitled to lawyers, they don't ask for a lawyer. And if you don't ask, you don't get one. So the first message we want everybody to know is if you're facing parole revocation, the very first thing you should do is say, I want a lawyer to represent me. If you're going to put me back in prison, I want a lawyer there. Second of all, you have to have a defense. So you have to be able to articulate that, yes, either I didn't do it or I did do it, but I don't deserve to go back to prison for it. And the more complicated it is, if you have evidence, for example, that you couldn't get, when you're in a jail cell, like, very typically what happened was somebody said, the parole agent says you didn't go to your substance abuse classes. You missed 5 of the last 6 classes. And the prisoner says, I was there, I signed in. All you need to do is get the sheet. Well, the parole agent is not going to go out and get that sheet. And if you're sitting in a jail cell, they're not going to go out. You can't go out and get that sheet. So you have no way to prove that you were in fact there. It's your word against the parole agent. You know how that always ends. You lose. But if you get a lawyer, then that lawyer can can subpoena the place, or can just go and get it, maybe send them a letter or whatever it is. And then you'll have the evidence that, yes, in fact, I went there. So you have to maybe articulate what the lawyer could do for you in terms of presenting evidence. And it may just be that it's a complicated case. Some are not so simple as I missed the dates. Some are like, well, a common one we see is you weren't living where you said you were going to live. You moved without telling anybody. And sometimes the issue is, did you tell them or not? But often the issue is, did you have a good reason to leave? So for example, if you're involved in a domestic violence situation, the right thing to do is to leave rather than get arrested again for domestic violence. And we see all the time parole agents say, well, you left and you didn't tell me about it. And we're like, yeah, but if I hadn't left, I would have been arrested. So of course I left. And then I let you know later, but yeah, it took me a day to let you know, but they violate you anyway. That's the kind of thing a lawyer can be really helpful in trying to prove that you had a legitimate reason not to do what you were supposed to do. So you have to be able to articulate that you have a defense and how a lawyer could help you. And the final thing that is helpful is if there's some reason you can't do it yourself. The most common one is either some level of illiteracy or some level of mental health problems, so that it's very hard to articulate in a good way in front of a panel of strangers exactly what your best arguments are. If you're not as literate as many people are, sometimes it's very difficult to figure out even what you're charged with, because these things are not written in plain, simple English. They're often very legalese. I've seen these long type forms which are single spaced and a page and a half long, which buried in there somewhere describes the parole violation, but not in any language anybody can figure out unless they have some legal training. So those are the 3 things that you kind of need to trigger. And that pretty much tracks the Supreme Court's decision as to who gets a lawyer. The Supreme Court did not say everybody does. It said basically if there's a reason you can't present it yourself, then you should be entitled to a lawyer. Unfortunately, most people still don't know that they're entitled to a lawyer, even in Illinois, where it's now been established for a couple of years. So we spend a fair amount of time trying to tell people, both when they're in, because people have more time to read and stuff when they're sitting in the jail cell than they do after they get out again. So we're trying to reach out to prisoners themselves while they're inside, so they remember this when they get out, and then they get violated on parole. But certainly trying to get people at the point where they are charged with a parole agent to be given some know your rights material, so right then and there they're aware that they can ask for a lawyer. I just think it's crucial. If it's not being enforced in your state, it's a good thing to demand and find a lawyer who's willing to bring those cases. Almost every state has a problem with this. We did a survey to see, what does every other state do? And the answer for most states was nothing, which means people are going back to prison who don't need to go back to prison. So that's my pitch here. As with many things, if you don't know your rights, you can't assert them, and they'll be violated if you don't know what they are. Illinois, again, the state I know best, so I'm going to talk about that, has sort of unintentionally done an experiment along this line. Because of COVID, they intentionally wanted to cut down dramatically the number of people that are going into prison. So therefore, they informally decided that they would not violate people as a general rule unless there was a new charge brought against them. And I think what they've seen is that it didn't matter. That is, that it didn't have any negative impact on public safety. That it was, in fact, a good thing because they kept the prison population dropped dramatically. It went down from about 40,000 to 30,000. And some other changes as well, but that was only a big one because a quarter of our entries were for these so-called technical violations. So I'm hoping that this experiment that they involuntarily did by mistake will teach them that that's a good rule to have in general. Now, I'm sure just politically they won't have a rule that says you have to have a new charge, but I'm hoping that they'll have a rule that says unless there's some special circumstances, really unique, then we're not going to. They always want a safety valve, right? They always want to be able to violate somebody for something, even if there's not a new charge. But I'm hoping that the rule of thumb in the vast majority of cases will be that you don't go back to prison unless you have a new charge. It absolutely is right. And, I think this experiment has proved that it also is not only right, but it's very doable.